Further hearing in the appeal of Manchester Ship Canal Company Limited against Vauxhall Motors Limited.
Yes. Just continuing from where we left off, I wanted to make a few submissions about some parts of the appellant's case, and not necessarily at random, but not always in a necessarily coherent order. But starting with the idea that somehow there's a gloss on the test, that the right in question must be either the principal right or the subject matter of the grant, or in some other way there has to be an idea that it is the main reason for the grant, or something like that. In my respectful submission, there's just no logical principle basis for that. Lord Justice Lewison construed the licence as a whole, as we have to, looked at it as a whole, as we would submit we have to, and asked the simple question, well, does this licence grant possessory rights? And I submit there's no point in seeking to dilute from that very straightforward principle, and it will only lead to uncertainty if we do. And there's nothing really in the authorities to help on this. My learned friend, Ms. Holland, sought to gain something from the authorities about easements and how an easement cannot exist if it grants the grantee exclusive possession. Well, that's all well and good, and we've seen in Moncrief and Jameson that there's a qualification to that in any event, that sole use may be granted so long as there's something that the grantor can do with the property. But those cases don't help at all. You can't build a case on the basis of working out what might happen if this grant was something else. It's not an easement, we've conceded that, and so we should move on and look at it as a whole.
Could I just ask you a question? Lord Justice Lewison was talking about possessory rights in the pipe.
Yes.
But could you say, since the airspace is enclosed, that there's also possession of the space in the pipe?
Yes.
Yes, you can.
Yes.
I don't think he quite deals with it that way. Just, I think it might be some property.
Absolutely. We say we have possessory rights in the pipes, the airspace enclosed within, the hexagonal, possibly octagonal chamber, and the, I shouldn't really call it the spillway, because the whole is the spillway according to the licence, but I think we know what we mean when I say the small s spillway, that part which is the actual means by which the water reaches the canal. We have possessory rights in all of that, including the airspace enclosed by the pipes. And it's worth emphasising that, as found by the Court of Appeal, well, it was by virtue of our concession, but found to be correct, that the equipment does become land. Once annexed, it becomes land. And so...
does it have to? On your case?
No, it doesn't have to,
no.
But it does, and we can't escape from it. In Simmons and Midford, Mr. Justice Buckley, I think it was, tried to get round it, but was slapped down and overruled, if that's the right way of putting it, in Mellowish, of course. And so we accept that it's land, but that's an important consequence, because it means that what my learned friend, the distinction that my learned friend tries to draw when she says, well, there's no rights in the soil itself, well, so what? We say we have possessory rights in land.
And what are the particular features that you say amount to the possessory right?
Well,
which features do you say particularly characterise it in this case?
In this case, you look at the grant, you look at the licence, the first question you would ask yourself, I would submit, is, well, who has the right to use this? Is it just us, or is it anybody else? No rights were reserved to the Ship Canal Company to use it. There were rights, and perhaps it's germane now to look at this. If we go to the license itself, it's at MS, the MS 199 I want you to look at. This is something my learned friend Miss Holland mentioned. It's in fact one of Vauxhall's covenants at 3D. Upon receipt of notice in writing from the Canal Company, forthwith to commence and to proceed diligent with the enlarged way of the spillway works to the size stipulated, for the purpose of controlling the discharge of surface water and trade effluent into the Manchester Ship Canal. I emphasise the definite article because it refers back, I submit, plainly to the discharge which is permitted, the right to which is permitted back a couple of pages, MS 197, clause 1.1 of the grant, full right and liberty to discharge all surface water. So it's our water. My learned friend, my learned leader, explained why there might be a need to enlarge the small S spillway, because otherwise, if, for example, it were found the flow of water was greater than was anticipated, it might disturb the flow of the canal and erode the banks. And so there are good reasons why this very limited right was retained. And so too, if we look a few pages forward to the other reservation, significant reservation, MS 204, clause 4 of the licence, where there's a right to the Canal Company to that's at 4.1, lay, construct, maintain, repair and renew, work, use over, under, along or across the spillway. So significantly, it doesn't allow them to connect. This is a grant. Ordinary principles of construction apply. So if a grantor wants to reserve something to himself, he has to do so expressly. Unless you're in the territory of necessity, for example, a way of necessity, the law won't reserve anything in favour of a grantor. And that's a situation here. So the aspects which in our submission mean that we have possession here are simply that it is clear from a construction of the grant that we are to be the sole users of this spillway, that the reservations are limited and specifically exclude a reservation to connect to it. And just to ram that point home very briefly, if we look at the variation agreement, it's a few pages on at, well, it starts at MS 223. We see at clause 4 a specific grant. This is at MS page 224. Clause 4, a specific grant to the Canal Company, a right and liberty to connect into and then discharge surface water from the land shown edge green on the plan annexed here too. And if we go back to 222, we see that very plan, and the green land is not massively clear, but it's to the left of the red rhomboid land. Into pipes and drains on the land edge pink on the plan annexed here too. So in other words, they were allowed to connect into our land for the purpose of then draining through the spillway, which was actually on their land. So one might wonder why they went to the trouble of negotiating such a right if they could have just connected to the pipes on their land which formed the spillway. They secured themselves a right to connect to our land, through our land, into the drainage system, and hence into the spillway. And whilst we're on this variation, whilst we're here, learned friend made a submission critical of Lord Justice Lewison, that he somehow thought that this variation was not important in terms of derogating it, so to speak, from Vauxhall's possession. To the extent that it had any relevance at all, it was in clause 1, which deleted the clause 3.1 of the licence. And if we go back to clause 3.1 of the, it's not 3.1, it's 3L of the licence. If we go back to the licence MS 203, that which was deleted was the prohibition on assignments or underlettings to others than associated companies, if I use that phrase. And how that can mean we're any less in possession, I would submit is very difficult to know or see.
Can I just ask you about 3L?
Yes.
Was that what prevented this from being an easement in the first place?
No.
Right.
No, that wasn't what prevented it from being an easement. What prevented it from being an easement, really, was the fact that the parties called it a licence.
Well,
yes.
there are some quite well-known cases about calling an elephant a crocodile doesn't make it a crocodile.
Yes.
Particularly in the law of landlord and tenant.
That's right.
What in
Street
substance,
being the main one, of course.
Quite. But what in substance means that this isn't... What about the substance of the rights granted, if anything, prevents them being rights in the nature of an easement, bearing in mind that it's perpetual?
It is simply the nomenclature in our respectful submission.
In other words, it's called a crocodile and therefore it can't be an elephant.
Yes.
That's not what Judge Behrens said, though, was it? He put reliance on 3L as well. And the reason, the way I'm thinking is if 3L goes and the amendment dates back to the date of the original grant, if that was what was preventing it being an easement, why isn't it one?
I need to remind myself, if I may, about what Judge Behrens said about that.
I'll try and find...
It's... we're in the territory of MS 169.
It's 86, paragraph 86. I also accept that clause 3L would not be appropriate.
Well,
without that,
yes, he does say that. I would not submit that was correct with respect to him. That easements can be fully assignable.
So it's just the name.
Yes.
But I mean, is the reason why it's not an easement that it's not sufficiently tied to a dominant tenant? On the face of it, it's fairly specific as to where the as to what bit of the world you can drain from through
Yes.
the spillway. I'm just puzzled as to why in substance it's not an easement.
Well, it is fully specific about the dominant tenement, of course.
Yeah.
Where are we going on this? I mean, you've accepted the finding that it's a licence, not an
Yes.
easement.
Yes.
I mean, if it was an easement, then it would be conceded that you win. So
Yes.
you'd
Well,
walk home.
indeed, yes.
If
If it were an easement, we wouldn't be here, so to
proceed
speak.
on that basis. So perhaps we should just, well, I don't know how far my lords want to take that question. But, I mean, I puzzled about that, but I mean, there we are. It's arrived in this court on the basis of the licence. And I'm
Yes.
reluctant to, Ms. Holland's going to get it.
Would it be a convenient moment just to assist on this so we don't come back to it later? I'll be very, very brief. In our skeleton argument, I did about 8 or 9 pages on all the reasons why it wasn't a licence, which
Wasn't an
in
easement.
paragraph 83 to 85, the judge at first instance touched upon. In my learned friend's trial skeleton argument, he did not seek to argue that it was actually an easement when we got to court.
No.
He said he was
No, no.
neutral on it. All of the reasons of analysis, one of which go to the very point that my Lord Briggs has just raised, that it wasn't attached to land and it was freely assignable like a contract, was one of the very reasons, and why the assignability prohibition.
Well, that's what I thought
is
Judge
consistent.
Behrens might have had in mind when talking about
Absolutely,
assignment.
was one of the main reasons, but there were an awful lot more, and they're all in the skeleton argument if you wanted to see them.
Have we got that?
You haven't, but we've got copies of it available for you to
Well,
see.
maybe we'd better have copies, but I'd
Yeah.
certainly be very reluctant to allow anyone to reopen this issue at this stage.
And I'm not seeking
And
to.
you're not seeking to. No, I mean,
It's been bothering me, so that was why
Yes.
I asked
Yes.
the question.
and it is always unfortunate if one finds oneself deciding an important point of principle on an artificial basis, but
Yes.
I think we're stuck with what we've got. Right, thank you.
Yes, and so we were looking at whether the licence grants possessory rights,
Yes.
in a sense. And my lords, my ladies and lords, one way of looking at it would be to ask yourself perhaps 2 questions. Question 1 would be, if the grantor, in this case the Ship Canal, did seek to break into our to the pipes, I use the definite article rather than the possessive, to the pipes, what remedy would we have? Would we be able to prevent that? If we're right about what we've said so far, we would be able, at the very least, to prevent that by way of an action on the basis of non-derogation from grant, which is exactly what happened in Lee and Stevenson. Although the case it says trespass, and we can have a very, very brief look at this. I know we've looked at it before.
What are we getting from that?
Lee and Stevenson.
Yeah, we looked at that, but it didn't seem
We
very
have.
helpful.
It says trespass, but in fact, in the judgment of Mr. Justice Crompton, he specifically refers to no man can derogate from his grant. And so our answer to that question, most assuredly, yes. The next question would be, well, if a third party, a trespasser, it started to interfere with the pipes, the spillway, the hexagonal chamber, could we ourselves, Manchester Ship Canal Company, bring an action to prevent that happening? I would submit yes, because we have sufficient possession of it, and the clearest authority for that now is, of course, the Dutton case, which we haven't yet looked at. So perhaps we ought to now. Albeit I acknowledge briefly. Dutton is in the primary volume it's Manchester Airport v Dutton at tab 8. Thank you very much. And it's on, that's in the paper, starts at MS 607. What's important to remember about this case is that, albeit it was about title to sue, the licence that Manchester Airport PLC had could not grant it exclusive occupation or indeed exclusive possession because of provision, because it was a licence from the National Trust, and the National Trust Act specifically prohibited them from granting exclusive possession. And so all the judgments, that is to say, of Lord Justices Chadwick, Laws and Kennedy proceeded on that basis. And the innovation, if you like, of what the majority held in Manchester Airport and Dutton was that when they brought their proceedings for possession, Manchester Airport weren't in possession. They'd been granted a licence, but they'd never taken up possession. And so we're a fortiori, because we are in possession. And so on that authority, I would say, again, yes. We would say yes. We if trespassers came along and interfered with the pipes, the hexagonal chamber, the spillway, we ourselves could bring proceedings to prevent that. And so if the answers to those two questions are both yes, we could prevent the canal company connecting, we could prevent trespassers disturbing, then why do we not also have sufficient possessory rights to obtain relief from forfeiture? And I submit there's no good answer to that. The answer must be, well, we do. And again, whilst I'm on the subject, Maloney Friend has submitted, well, there's no forfeiture of the spillway equipment because we can take it away. Well, this submission was never canvassed below, either at first instance or in the Court of Appeal. So we don't know, because the evidence doesn't go there, whether or not we could actually take it away without destroying it. But that's not the point. The point is, what we forfeit is our possession of land, which is the spillway. That's what we forfeit. We might be able to break up and take away a load of concrete, but that's beside, we would submit, the point. If I may come back to track, yes, staying with the licence and looking now at clause 5. We go back to the licence and see that clause, which both before His Honour Judge Behrens and the Court of Appeal, Maloney Friend maintained was not a forfeiture clause. That's no part of the grounds of appeal. But Maloney Friend has again made submissions, Maloney Friend, Miss Holland has again made submissions to the effect that this really doesn't look much like a forfeiture clause. Well, in my respectful submission, our respectful submission, if this has been a lease and you had asked yourselves, any lawyer had asked himself or herself, is this a forfeiture clause? They would say, well, of course it is. The fact that you have to give notice before exercising your right to forfeit is neither here nor there. And that is fully established, or was fully established in the Court of Appeal in the Clark case.
Is that point live here? Oh, it's no longer live, is it? Here?
No, it's not. But Maloney Friend raised it, and she criticises Lord Justice Lewison again for, in this way, for in a way which is wholly wrong, in that somehow it undermines the doctrine of waiver, but well, it absolutely does not, because you can't waive a right to forfeiture until the right to forfeiture has arisen, and it doesn't arise until after notice has been given. So the fact that there is a precondition of the right to forfeiture of notice, it doesn't go anywhere.
Well, the statutory forfeiture regime is absolutely dependent.
Well, quite. Section 146, and this is where clause 5 of the licence closely follows section 146, using the almost identical words, where it says the company may, by notice in writing, require Vauxhall to pay the renter in arrear, or to pay reasonable compensation for said default and remedy the same if capable of being remedied. These are words lifted almost exactly from section.
Yeah, I wonder what happens if it's not capable of being remedied.
Well, if it's not capable of being remedied, one would go back to the learning of that of landlord and tenant.
Yeah.
It doesn't mean you can't have relief.
But I mean, also, in terms of, say you fail to repair, they
Yes.
serve a notice on you to repair,
Yes.
and you dilly and dally and don't do it within a reasonable time, they then purport to determine it. Now, on their case, that would be the end of it.
It would, yes.
In your case, you could go to court and say, well, actually, there's still a reasonable time left, but if there isn't, we want relief and we're prepared to pay suitable damages and so on.
Or better still, we have now repaired,
Yes.
and everything is right.
So, I mean, on that case, the issue will come to court in one form or another
Yes.
if there's a dispute about what is a reasonable time, whether you've done enough, and so on.
Indeed.
And that would be very much similar to a lease situation.
Yes. And this, in a sense, brings into play, going back to how His Honour Judge Barron saw it, or almost seeing this whole agreement almost as sui generis. And if we go to how he dealt with it, again back to his judgment, albeit briefly, we can see it's at about 95 to 97, MS 170.
170?
Yeah. Where he looked at essentially what we're looking at now. He adapted the words of Lord Justice Robert Walker in On Demand. Contractual rights which entitle Vauxhall to indefinite and exclusive use of the spillway so long as the annual payments are duly made, in which qualify and limit MSCC's general rights in the spillway, cannot aptly be described as purely contractual rights. So there he's using Lord Justice.
That's quite attractive on its face.
Yes.
What he's done is to get rid of the word possession and substitute the word use.
Yes, which is essentially part 3 of our case.
That's why I wondered really whether this sort of focus on this rather difficult word possessory, it may be slightly misleading, because what one's concerned is, it's grown up in the context, as Holland says, of personal property. But one's really looking for something to describe the use you're making or the rights you have to the particular property in question.
Yes.
And if it's a right to use a spillway, whether it's an easement or a licence, described as possessory isn't really particularly helpful. The important thing is you have the right to use it.
Yes.
Indefinitely.
That is essentially part 3 of our case.
And you say that springs straight out of the scap trade, because a time charter doesn't, but a demise charter does give you a right to use the ship.
Yes. And of course, that's what that's what was one of the factors in celestial aviation, where the leases of aircraft were in question. No question there that they did transfer possession, unlike the time charter, which didn't in the scap trade. The aircraft leases did, whilst the charterers, the lessees, had the aircraft. They had possession of them. They flew them with their crews. They fueled them with their fuel. It was a completely different situation to that in the scap trade, where in the time charter classically, the crew are servants, employees, I should say, of the owner,
Yeah.
and they provision the ship too.
Yeah.
And so one of the key aspects which persuaded Mr. Justice Hamlin that relief from forfeiture wasn't available in that situation was the fact that two main things. One was that the lease, the aircraft lease, was for merely a period of the aircraft's economic life. And the other was actually looking at the termination clause itself. It didn't qualify under Lord Wilberforce's condition that it was inserted as a security. It was, and Mr. Justice Hamlin had no difficulty in making that distinction. And we haven't seen any flood of cases in relation to chattels, in relation to leases of chattels, where people have disputed whether relief from forfeiture is available or not.
Yeah.
Precisely,
Anyway, we're concerned with something rather different here.
we are indeed very different.
But
The point, my
I didn't mean to interrupt your sentence. I'm sorry.
No, the point I seek to draw out of this short passage in His Honour Judge Barron's judgment is that he was treating this licence very much as sui generis. And before I finish this part of my submission, I take you to the other part of On Demand, which was the judgment of Lord Justice Millett.
Just before you go there, what's the difference between indefinite and exclusive use and the factual element of possession of a chattel?
Well, in relation to chattels, our submission would be that if you have a hiring of a chattel for a short period, even if you have exclusive use of it or possession of it, and in my respectful submission, those two terms could be used interchangeably, as you did in celestial aviation. There is not the same indication there in the nature of what has been agreed to show that the parties intended the termination clause to be a forfeiture clause in the sense we use that phrase here and now. And it is, of course, the intention of the parties which is the basis of all this. We see that as long ago as the 1720s, I think it was. And at a very high level of generality, it is right to say that equity intervenes here because the behaviour of the forfeitor is unconscionable. But that, of course, begs the inevitable question, well, why is it unconscionable? It is unconscionable because the forfeitor is seeking to rely on what might be termed his strict legal rights in the face of what was the plain intention of the parties when they entered into the bargain. So that's why it's unconscionable. We're not seeking here to traverse the abyss into saying that equity can intervene whenever it thinks something is unconscionable. There has to be a reason why. And that
Yes, I'm
reason,
sorry, you seem to be moving away from
I am a bit. I
But
caught
there
up
was-
in the flow of my submission.
But there was a secondary, which is clause 5 of the licence is really relevant to this question of unconscionability, isn't it?
Yes.
Because you had notice. You had 28 days notice. And one can think of circumstances where the breach of covenant could have been much more serious to the ship company, such as where you were busy discharging pollutants into the river in breach
Yes.
of covenant. And then the ship company would have have an urgent need to, as it were, dispose of your possessory rights, if any,
Well,
get you out.
Indeed, and that's where we would submit to the clear distinction which Lord Wilberforce drew between the three cases. That is to say, forfeiture for non-payment of rent, fraud, mistake, etc., and forfeiture in relation to other covenants, which relief from which is only available where appropriate. Whereas, in relation, as we all know, in relation to rent, payment of money, it's virtually automatic.
Well, would you accept that in some cases the payment of money on time in accordance with the contractual schedule is an important term of the contract against which the court might not feel it was right to give relief from forfeiture?
Milady, indeed I would. And in those circumstances, that would militate very strongly against the termination clause being a forfeiture clause.
As it did in the scrap trade.
Yes.
There will be those cases.
There will
So
inevitably those cases, and as happened, and indeed in celestial aviation, the courts had no difficulty in saying, well, this isn't a forfeiture clause.
Right, well, you were about to take us, were you back to on demand? Or,
Yes,
although-
just if I may very briefly, it's at tab 10 in the bundle, MS page 638. And as we know, the Court of Appeal held that the equipment leases in question and the termination clauses in the equipment leases in question were forfeiture clauses, and relief from forfeiture was available. But they held equally that they couldn't grant it because the equipment had been sold in the interim. The House of Lords decided that that was wrong, but indeed there was no appeal in relation to the forfeiture point. So you may be wondering, why are we going here? But there is a reason. It is in the speech of Lord Millett at MS page 649.
Yes, well, we looked at that, and that's helpful because it adopts what Lord
Yes,
Justice Walker,
yes, and what?
and indeed the passage which is then adapted by the judge in this case.
Yeah, indeed, and Lord Millett refers to the need, not unnecessarily, I paraphrase, to restrict the exercise of a beneficent jurisdiction without any rational justification. Here, we submit the appellants are seeking to do is just that. They are seeking to restrict this beneficent jurisdiction by their attempt to undermine the clear words of the board in Cukurova. Lord Justice Dillon in BICC.
Yes, I mean, would you say, I have the impression there's been a sort of shift in judicial policy from sort of Lord Justice Oliver in the early 80s.
Oh, yes.
You shouldn't extend it. And you have, to some extent, Lord Hoffman in the Privy Council saying,
Yes.
careful about extending it. But then in this judgment and in Cukurova, you get a slightly more generous approach to it.
Indeed so.
Yes.
Indeed so.
Right.
So I'll leave that, and then if I can go back to my notes, Yep. If I can. Perhaps finish with a brief summary of our submissions in relation. Well, no, before I finish in relation to part 3 of our case, there is one further aspect of the applicant's case I want to take up. And that is, in her oral opening, my learned friend Miss Holland said that relief from forfeiture is only available for, I hope I got this right, licences in relation to land, if the licence is protected by an estoppel or coupled with an interest, and I paraphrase, that's what I understood her to be saying. Now, that in itself undermines the definite way that the matter is put in the case, the appellant's case, and in the summary, where it says quite firmly and distinctly, relief from forfeiture is not available in relation to licences of land, and you have to have a proprietary interest in land. And so what's happening here is that instantly there is if you like, an acknowledgement that goes too far, and that some licences will qualify. And that we submit, undermines her case. And then turning lastly, before I close, to what is in effect part 3 of our case, which does concentrate on this idea that it's not necessary to search for a possessory right. Yes, by all means, that is the orthodox view, and that was the view taken by Lord Justice Lewison in the Court of Appeal. And we're perfectly happy with that in a sense, because of course he found that there was a sufficient possessory right to ground the jurisdiction. But this all, what we say is this rather ignores what is the foundation of relief from forfeiture. And you start off, as my own friend Miss Holland did, as saying, well, you're losing something. There's got to be something you're losing for forfeiture to come into play at all, as a matter of concept, as a matter of language. And so what is that something? We submit that yes, it has to relate in some way to property, real or personal, corporeal or incorporeal. At its strongest, of course, you're losing ownership, absolute ownership of property. And therefore we come to mortgages. And let's not forget the way mortgages over the years came to be developed until the reforming legislation of 1925. The classic way of creating a mortgage was to convey the land so that the mortgagee became the legal owner of the land with a right to redeem, a contractual right to redeem, which was exercisable only in a relatively short period of time. So that was a classic way. And so it was that equity intervened to create, if you like, the equity of redemption. And there are two different concepts, of course. There's the right to redeem, which is a contractual right, and an equity of redemption, which is an interest in property and is fully assignable. And so that equity of redemption was based on two threads, really. One was that equity looks at the substance and not the form. And the other was that otherwise it's unconscionable for the mortgagee to insist on his strict legal rights, where that would go fully in the face of what was the true intention of the parties. And so we can see that, as was identified in the Cukurova case, that the equity of redemption and the law of mortgage and the law of relief from forfeiture are very, very similar concepts. Now, it is right to say that in relation to mortgage, the variety of property that you're mortgaging doesn't affect your rights to redeem. Nobody has ever suggested, or perhaps they certainly don't now, ever since Cukurova anyway, that your equitable right to redeem is limited to a mortgage of land. It's certainly available in relation to all forms of property. So why and now it is fully established that right to relief from forfeiture is available in respect of all forms of property. Question is, though, this is what we're dealing with now, well, what rights in that property do you need before the jurisdiction arises? And here we say that, in essence, the right need only be a right to use. We're, as I say, we're perfectly happy with possession because we say we had it. But a right to use is sufficient. And the control, the ultimate control, is always going to be in a close examination of the termination clause, reading the grant or contract as a whole in the context of all the circumstances which were known to the parties at the time of the grant. So classic contractual interpretation. And we have seen, we submit, that where the law has extended, where the law has developed since Lord Justice Oliver sought to prevent that development, we have seen that the courts are able to tell whether the agreement was such, the circumstances were such, that this was the intention of the parties. And here, I would submit, well, it's not challenged that it was. So it begs the question, well, why should equity turn its back on us, where it is a matter of concession now that this clause was inserted as a forfeiture clause? That ex hypothesi, therefore, the parties expected somehow relief to be available, if that's what its true purpose was. Mere security, that's the whole point of a forfeiture clause, that is mere security. And so I haven't gone into each and every authority that is cited.
Well, no, but I mean, the way you put it, it's a fairly straightforward point, good or bad. So I think we have it right, is that?
One moment. I think she's gone. Yeah.
And it was just a small point I was going to make. You asked about what
On demand.
what Lord Justice Lewison said about airspace and the infrastructure, and the answer is in paragraph 60 on page 138. He did deal with the point.
Oh, good. Thank you. My fault.
Thank you. And so, unless there's any further questions or clarifications, well within the hour,
Yeah, well, thank you very much. It's been very clear.
our submissions.
And I take it, Mr. Norris, you're happy to leave things there. Right, thank you both very much indeed. Ms. Holland.
Thank you, my lord. Might I start with the issue that you raised at the conclusion of yesterday afternoon, my lord, which is the point that's also been the subject of some discussion, clause 5.1 this morning. And I wanted, if I may, just to stand back for a moment and look at a contractual licence scenario where the parties want to have a termination provision in it. Now, what is wrong with having a termination provision in the licence which gives a notice provision with the opportunity to put it right and breach upon that notice procedure having been followed through. In any contract, one can have that. Why should that mean that we then start with some sort of presumption of trying to do some comparative exercise? Now, I'll come to that comparative exercise specifically in a moment. But can I also ask us to stand back to the starting point principle that we looked at from Golden Union? In Golden Union, specific performance wasn't granted when they were 10 minutes late, and the contract could be terminated under general principles. So let's say the parties choose to make time of the essence for termination. 10 minutes late, they would not get specific performance. So here, for example, if the licence had had a termination provision which simply said, to take Lady Arden's point, if you're late in making payment, time is of the essence, they would not get specific performance. Now, once you start to look at it from that perspective, you see why it would be wholly wrong and wholly inconsistent if we started off with some sort of presumption about relief from forfeiture and look at the clause in that way. Because that is where we would get to. The parties are here...
I think all you're saying, and I certainly don't think it would be controversial, is a matter of construction of the particular contract.
Absolutely.
Clearly, if it includes the word time is of the essence, well, time would be of the essence.
But here they chose to put a termination provision in, a more generous termination provision. But in the same way as it may be with any contract performer, the party to whom that obligation is owed may take those matters very seriously, and we gave them the opportunity.
Just to be clear, the authority to which I was referring was a case where a company had forfeited shares for non-payment of calls under its articles for exactly the 10-minute type point. And the court said, it didn't say there was no right to relief from forfeiture. It said no relief, because the company needed the money to construct the infrastructure it was constructing, which was actually Liverpool Waterworks.
Yes.
So that's looking at a different point from Scantrade. Scantrade is looking at it and saying, no, this is not a forfeiture clause.
Yes.
It was saying this was a forfeiture clause, but no relief because of the 10-minute point.
So here, once one starts...
As you say, in Union Eagle, one had a different result on the interpretation of that contract.
Well, that was a situation. Yeah, absolutely, we're looking at termination, but what I'm anxious to do is to not start off with any presumption simply because of the context of this case. And here, of course, they were over 6 months late. And breach is obviously something which my client is understandably doesn't want to continue a relationship with if somebody's going to take that approach to performance of their obligations. So if one is going to look at equity consistently, and that rule, the golden rule, I would say, that comes from that case, is that the fundamental principle is that lateness will not just be overlooked. And why here, therefore, on this clause, should suddenly we have a situation where over 6 months allows it. Now, I then turn to the very specific point about why you can't infer contractually there was some sort of intention about forfeiture from that clause. And I don't resile in any way from any of the observations that we've made throughout in relation to this clause. Now, taking it in stages, one of the fundamental points about the clause, and you'll forgive me if I just get it in front of me, is that it is entirely consistent with the position that we have advanced in this case, because a standard forfeiture clause, and we've probably got one in one of the other authorities throughout the bundles, talks about either the words forfeiture or re-entry and taking back the premises. It is therefore
do we happen to have a convenient one anywhere in the authorities?
We will find one. We've
might
got lots.
Be just useful anyway, but you say they would certainly normally expect some reference to forfeiture and re-entry.
Forfeiture or re-entry. And going back into the premises, all forfeiture clauses have that sort of language in because they're all consistent with taking back possession. We will re-enter. They'll either have the subject heading of forfeiture, or they will have the words re-entry or re-enter or forfeit. And those words are appropriate in that scenario because they are taking back possession. They are taking back the relevant form of interest. So therefore, it's highly significant in this case that no such words appeared. You don't have anything in that clause which indicates taking anything back. So therefore, it is far more consistent with a termination provision. Now, a Section 146 notice by statute has said that once your right of forfeiture is crystallised, by statute you can't then enforce it without a notice. But Section 146 has nothing to do with the payment obligations. That's for other breaches. Now here it's included for a payment obligation. So there you have the first distinction. What is more, as a second distinction, in 1962, as we know from looking through the historical discussion in Shiloh, no one was very clear about to what extent there was an inherent jurisdiction in relation to relief and forfeiture for other breaches. And that's appearing in this clause. Then you have this scenario about the fact that whereas in forfeiture generally your breach accrues, and either there's a statutory position about the service of notice or a demand waives it, here you've got a totally different structural arrangement. You have a structural arrangement where the right of termination accrues upon termination of a notice. That is different from forfeiture, where the right of forfeiture accrues upon non-payment of rent or on breach of performance. So we already have, I would say, about 7 or 8 structural differences between forfeiture and what is this termination provision. So I go back to my original question. Let's not make any presumptions or assumptions that we're trying to find some comparison with forfeiture. If I just put the suggestion out there that in all other respects, for the sake of argument, you would contend this was a contractual licence and we were looking solely at this clause. How then could the draftsman have done a termination provision with a notice procedure in any other form that would then protect him from this argument? It cannot be that that simple contractual mechanism that was set out somehow takes overriding importance in relation to the interpretation of the document. And just to go back to what I said about the rent, when you have a situation where the right of forfeiture accrues upon non-payment and you don't have a notice procedure, and this goes back to a point that Lady Arden raised yesterday, that in residential tenancies it was only in the Common Hold and Leasehold Reform Act, Section 167, that Parliament then put a restriction just for residential leases that they should have a warning notice.
Very much. That's what it was. Thank you.
So, in my submission, just dealing therefore with the point that you raised at the end of the day, that there is no quick route against my case pursuant to that clause. So I then turn to respond as succinctly as I can on the various points which Mr. Edwards has raised. Perhaps if I might just start off with a small observation. It would appear, I think, that the respondent no longer pursues the argument that it is sufficient that a termination clause has as its only object the security of performance as a test for relief from forfeiture. I think that is now clear. And on that basis, I wasn't proposing to respond by reference to the article by Dr. Turner, for example, unless you would find that of assistance. On that footing, just 2 further consequential observations are to be made. The first is, just so that you were aware, in the event that that was still somehow considered by this court, the evidence of course, is not there to support any submission that the only object of this clause was to secure performance, so that you're aware of that. There is no unappealed finding on that, and Lord Justice Lewison's finding doesn't. Now, this may be completely academic, but I just wanted to note that point. The second point I make regarding that is that you may recollect that
Sorry, I'm not sure I'm with you. I mean, I understand your point that it's not being argued that it's enough.
Yes.
That's the only purpose.
Yes.
But that it is the only purpose was a point I put to you yesterday, and I didn't get a clear answer as to what other purpose there was.
The position on this, on the evidence to date, is that the issue was never argued at first
But I mean,
instance.
it's not a question of evidence, it's a question of we're not concerned with what the people thought at the time.
I'm sorry.
With what this clause is doing in this.
Absolutely, I apologise.
And-
That's right. But what I meant was the issue wasn't argued at first
No, I'm
instance.
putting it to you.
But
What other purpose than enforcement is there?
absolutely, there is another purpose, and it goes back to what I said earlier, that in this scenario, my client doesn't, if one looks at the amount of money, the very, very small amount of money, performance of the obligations and payment of the sum of money, obviously another clause, purpose of that clause is my client does not want to have a continuing relationship with a party who takes that privilege of this permission, which is perpetual, with that lack of regard for its obligations. So the £50...
Her purpose is to ensure the credit worthiness or trustworthiness of the other party?
Well, I'm not sure I'd necessarily characterise what I think the lack of respect for its contractual obligations and for the ongoing relationship. If they have the privilege of a perpetual licence, a perpetual permission, which is what we say it is, then in my submission, that was conditional upon those payments being made. And why should they continue to have that privilege and that ongoing relationship?
No, I've noted that. Thank you.
I mean, there might have been all sorts of reasons why the rental was very small and nominal, because we don't know what the position was about the maintenance of the walls of the canal and the drainage obligations. And we cannot speculate about why it was £50.
Absolutely. And that's my very point, because the issue wasn't argued at first instance about what the only object was. What happened was that in the judgment at first instance, an observation, I think, about primary object is made.
Yeah.
So we appealed that, and no determination appears on that issue in the judgment of Lord
No,
Justice
I
Lewis.
understand that, which is why I
Sorry.
put the point to you and I got your response. Thank you.
So it would need a lot more scrutiny for exactly the reasons that Lady Arden's raised. So I move then to the point made by Mr. Edwards about Bland and Ingram. Very briefly, I can deal with this. I think there were just 2 points. So that you are clear, there is no question of Bland and Ingram deciding that an equitable chargee was entitled to relief under the inherent jurisdiction. It is, as I think it was both Lord Commenton and Lord Briggs made the point, that that was entirely through a statutory route and statutory mechanism by which they allowed the equitable chargee to stand in the shoes of the tenant on the basis that they had every obligation to achieve their security. So Bland and Ingram's does not help you in any way in my submission in this case. And that's clear from the head note itself at the conclusion of the head note. Now, there was another point raised about Bland, which was some wording of Lord Justice North that I should deal with very briefly. And it's at page 423 in the bundle 1 of the authorities.
So sorry, can I have that page number again?
Yes, 423 in bundle 1. Now, Mr. Edwards himself described this as obiter, and in my submission, it doesn't assist you at all. It wasn't in the same context. It may be a bit of a throwaway line, but it's quite capable of being interpreted in my client's favour. And it's the sentence at D, my lord,
Yeah.
that you were taken to, the sentence where it said, the authorities show that the cases in which the inherent jurisdiction to grant relief against forfeiture and non-payment of rent has been exercised have been restricted to those in which the person claiming relief is entitled to possession of the land, or at any rate, which is not necessarily the same thing, has a legal estate or equitable interest. So you could just as easily interpret that as him saying, when he uses the words at any rate, rather a legal estate or equitable interest in it. I don't think it takes us here nor there. But in fact, if we were going to look at it, we'd need to look at what was said in the other judgments, where there's comments about a distinction between proprietary interests and a right to possession. In my submission, the case is just so far away from what we are dealing with that these one sentences should not be regarded as having any significance for the purposes of determining this appeal. Now, the next point that was made by my learned friend was a point that in relation to rent, non-payment of rent in the landlord and tenant context, non-payment gives you an automatic right to relief. Now, I'm not sure how that point is of any assistance in deciding what the scope of jurisdiction is in this case, but just so that you're clear, I hope Mr. Edwards will be entirely in agreement with this. That, of course, is entirely the creature of statute. Before that, it was a matter of the inherent jurisdiction, and it may well have been a settled practice to give relief upon full payment, but that didn't mean that it was the automatic course if the justice of the case didn't require it. We can take you to authority on that if you would like us to do so, but it seems to me immaterial.
I made the same point.
Thank you. Might I just also deal very briefly with another small point? Twice in the course of the submissions on behalf of the respondent, reference was made to the fact that it had been an attempt had been made to register this as an equitable easement. Can I ask you to totally disregard that? Because what seems to have been forgotten is that at first instance we took the court to a good deal of law and discussion that at that stage they thought, under the registration system, it was thought that it also included licenses. So can we just forget that particular reference, if I might ask? Mr. Edwards described the test of possession test as being wholly uncontroversial, well established and not difficult at all. In my submission, that contradicted what the respondents said in their own case, where they accepted there was some problem. I think it was paragraph 18 of the respondent's case with the test in relation to adverse possession. But they also said in their respondent's case that a court shouldn't be too technical about possession. Now, what I say regarding that is, how can that be the right approach in relation to matters of property law when people are deciding upon the nature of their transactions, that they should have the risk of it going to court in order to determine their risks under that agreement. And that's a point which is made in one of the authorities on certainty to which we've directed you in our appellant's case, that even any ambiguity in the test which might invite litigation is to be guarded against.
Could they disclaim in their contract any right to apply for relief from forfeiture?
Well, I thought about that, but actually it seems to be very clear that you can't contract out of equitable principles. I think that must be the overriding principle.
I mean, it might be relevant to whether you would get it in discretion, I suppose.
Certainly.
You can't contract out of the jurisdiction, perhaps.
No.
But there's some authorities that are on that point.
Well, I did start to have a look for authority, and then I just stood back and I thought, well, it can't be right that if that was right, then all landlords would try and contract out of relief from forfeiture in their leases.
It's different, obviously, in landlord and tenant where there are statutory provisions, but we're now looking at the inherent jurisdiction. Can parties contract out and say it's the intention of the parties that there should be no right to claim any relief from forfeiture?
I don't think that they can. I think that would be struck down by the court.
I mean, I wondered that too, and I mean, it doesn't arise here because there isn't a clause, but It'd be interesting to know whether
That-
there's any cases on that or any learning on it.
Well, certainly
I mean,
on
really,
my initial
First instance,
perusal,
it's a purely commercial transaction, and I don't see why parties shouldn't be able to contract out of anything. There's no public interest in it.
certainly on my initial perusal, there was nothing, and I thought, well, perhaps this is one of those situations that something so obvious. It's one of those cases where you don't find much discussion or authority on it, but I'm more than happy to...
Well, don't worry now. I mean, if either side happens to be able to find any learning on that, we'd be quite interested, but I don't see it as being crucial to this particular case.
Thank you. Might I then turn to a point which was said that I undermined my own case by saying that a licence coupled with a grant or a licence which had
Well, I
led...
don't think we need to spend a lot of time on that.
Can I just correct that?
Speaking
Because I made it
myself.
absolutely clear that it was only when a licence became an interest in
Yes,
land.
well, that's what you're saying.
And there's a reference in the transcript. There's absolutely no undermining of my case there.
We're not in estoppel country, so we don't need to worry about that.
Thank you. A brief point regarding the 1997 deed. And the point here, I think, that Mr. Edwards sought to make was that by if the point works entirely in my client's favour. What the 1997 deed did, it allowed my client from another area of land to discharge onto another area of Vauxhall's land. I had, as a client, had to do that. I had to have that right. There was no pre-existing right. But it didn't grant any right in relation to the spillway, which is why the point operates in my favour. If it had been thought that I had excluded myself from any use of the spillway, then a right would have been granted in relation to the spillway.
Well, it would easily be implied. I mean, if you have an express right to discharge your water into somebody else's treatment plant, and both sides know that that treatment plant is discharged down the grantee's land, I mean, it's obvious, isn't it, that the court would construe it as including a right that the water should go out through that discharge.
My point, my lord, is simply this doesn't take any support
No.
in this case. Yeah.
I understand that.
Thank you. So far as the submissions on Manchester Airport and Dutton,
It could also be that it wasn't a right that should go out through the discharge, but should be treated in the same way as Vauxhall treated the discharge on its land.
it could be that.
Not necessarily
It could be.
the same way.
Manchester Airport and Dutton, so that I don't waste unnecessary time, my submissions, as we've set them out in our appellant's case on that, are quite extensive, and I'd ask you to look at those in response to that.
Thank you.
Can you just give me the paragraphs?
Yes. It's at page 78 of the core volume, and it's paragraph 68 all the way to 73.
And core and electronic?
It's 78 through to 80.
Oh, that's the electronic number.
Yes, MS 78.
Thank you.
Yes, it's a not uncontroversial decision, as you say. Yeah.
The next small point I need to deal with was the suggestion regarding our ground of appeal, where we say that it was wrong to determine this case by reference to the spillway and circumstances where we didn't forfeit the spillway. And it was said we hadn't taken that point before. Well, no, we haven't, because it only arises for the very first time from the judgment of Lord Justice Lewison. It's never been the subject of any issues before. There was a question, I think, Lord Conworth, regarding had there been a shift in the judicial approach. And the case law, if one looks at the chronology, in relation to the Golden Union case, for example, which I think was 1997, wasn't it, Golden Union? But if one looks at Cavendish and Matt Dessy, which is at tab 31 in the bundle of authorities.
Sorry, which case is that?
Cavendish and Matt Dessy,
Yes.
which is in 2016, which is a case on penalties.
Could you just give us the MS number for that?
Sorry, page 923 in bundle 2.
Electronic?
923.
923. Thank you. Sorry, I misheard you. 923.
It's quite clear in that case, which there's some discussion generally about equitable principles, but it's clear there that they are saying the rule on penalties should not be extended at all. So I don't think there is, if I might respectfully suggest, anything in relation to forfeiture and relief on forfeiture which expresses any more generous approach other than the admitted move by which all forms of property can be the subject matter of relief and forfeiture. My learned junior tells me that we've got copies of the closing submissions.
Oh, thank you very much.
Might it be a convenient moment to hand those up?
Thank you.
That's the closing submissions, is it?
At the trial.
Yeah. And is this where the easement point is fleshed out?
Yes.
The not an easement point
The
is
not
fleshed
an
out?
easement point.
Yeah. Do you have some paragraph numbers for us for that?
Yes, on the extract that you're being given, you'll see in the index at the front. I think it's been highlighted for you.
Well, what, 27?
Yes, and so then behind it, oh right, I'm told the numbering changed. So if we go to it's page 7, might I ask you to correct that? I do. It's at 7. Is that right? Yeah.
Internal
so it's
page 7.
It's internal page 8 where it starts.
Oh, the not an easement point.
Yes.
8.3 onwards.
And then the specifics of it. Yes, if one goes to the bottom of page 11, the terms of the licence, and you'll see make it clear that it gave rise merely to a contractual licence.
Yeah.
And then a summary of the points, described as a licence at 9 occasions, no reference to easement, freehold interest, fee simple or leasehold easement. And it goes on with a whole variety. And most specifically, it flows through all the way up to
Well, the end of 8.4.
yes.
Yeah.
Yes, so page 23 internally. And that's why His Honour Judge Behrens, in those paragraphs we looked at earlier, dealt with it in some detail.
Right, well, we've got that. Thank you very much.
Might I come back then in relation to the general point flowing from what Mr. Edwards is saying, is that a right to use means as a possession. And we are moving well away here from what the substance of that licence was. The licence was a permission for an intermittent flow of discharge through an airspace, as we now know. A permission to do something that would otherwise have been a trespass, and it was an ongoing permission because it was perpetual, but it was subject to that termination. So it was a permission for an intermittent flow through a discharge. That is what the right granted was, together with the construction of the facility, which then became subject of our ownership, to afford that right. The danger of going into all of the possession cases in personal property is that possession in relation to real property, as we've debated so far, you cannot confuse a use, which says very little about the extent of use, with a grant of a right. De facto use does not give rise to a right of possession. And that's why looking at language in relation to possession in personal chattels is so confusing and not comparing like with like. Now, in fact, in the event that you want to analyse those personal property cases, you'll see when you look at them as a totality in personal property law that there's actually no case, put before you at least, where relief has been held to be available in the context of possessory rights only. There's no express finding in the on-demand case about the nature of the rights. They're described as possessory in celestial aviation, but as proprietary in Warnborough and Garmite. Now, as I've indicated earlier, I take no issue with the development of the law on personal property. But it doesn't take much to appreciate that possession in relation to land and a right to possession, which has achieved this degree of legal analysis over the years, is something very different than what one is looking at when one is considering how you possess a chattel, small or large. Rights to possession in relation to land are necessarily conceptually very different. And so we have the general point that what is an issue in this case is whether a contractual licence is susceptible to relief from forfeiture. Against the backdrop of the law to date, if you were to regard that right of discharge as being in some way possessory, it would undermine and confuse all the distinction in land law between leases and licences. It would confuse and undermine all of the distinction in land law in relation to what can and cannot be an easement, and it would confuse and undermine all of the distinction in contract law about a termination provision whereby you can terminate it if you put it as time of the essence and your remedy then has to be specific performance, and you can never get equity assistance for being 10 minutes late, or whether you choose to put a termination provision in a more generous way, giving them the opportunity, in which event you can be over 6 months late. And I say that therefore we should stick to the simplicity of the established rules that the parties here chose a licence. It was the subject of obviously legal negotiation. It has a great deal of extensive terms, which you've seen analysed in the closing submissions about why it was chosen to be a licence. It hasn't actually ever been argued to the contrary. And that must carry with it the rights which were known to exist in relation to licences. And insofar as my learned friend says that just because we've produced one textbook reference which says that you don't get relief from forfeiture in relation to a licence, we didn't think the court would appreciate for us to put lots and lots of textbook references in. There's no case which has ever said that a pure licence has relief from forfeiture, notwithstanding the huge multiplicity of authorities that we do have on relief from forfeiture over the centuries.
Right.
Might I just take a very brief moment? My learned junior has just, I think, found a standard forfeiture clause, which he made a request
thank you.
for. And is that clause 13? Is that clause 13? So the position on this is that we've brought some standard precedents for forfeiture clause, if that would be more convenient. We do have some copies of that, but we have...
Well, why didn't you put, if you've got one, that's probably better. Where's that from?
In the case law, the closest we get in the authorities before you is at page 700 of volume 1 in the authorities in Richard Clark and Widnall.
But if you've got a standard form, that might be even more useful.
Oh, yes. Clause 13.4.
There it is. The re-enter.
It appeared that the word forfeit only appeared in a marginal note. The word forfeit appeared only in a marginal note.
Yes. Anyway, you've got a pretty clear re-entry.
And at letter F, you'll see the word re-enter.
Yeah, I got that. Yeah.
Okay, well, I think that's probably good enough. Ms. Holland, don't worry about taking more time.
This is the precedent.
Yeah.
Thank you. Is that all right? Are they highlighted?
Right, what's happening now?
We were just highlighting it for you. That's...
Well, look, don't worry. I mean, you can do that outside court. We don't want to hold everyone up for that purpose. So that completes your submission, so did?
Unless I can assist the court further.
No, I think not. Thank you. Well, thank you for all of those very interesting submissions on not an easy point. And thank you for all those who assisted and behind and on the side. Obviously, a lot of work has gone into this at all levels. So we will go away and do our best to work out the answer.
With my Lord's leave, can I just give you the reference to the Liverpool Waterworks case in case anybody wants it, because I've got it open in front of me and the citation was wrong when I looked for it. It's called Sparks and Liverpool Waterworks, 1807-13, Vasey Junior 428, 33, English Reports 344.
Thank you very much.
Good. Well, make of that what you will. Thank you.